Over the next 3 lessons, we're going to focus on one simple theme: distributions from your estate. In other words, when your estate plan says, "This goes to that person," how do you make sure the right people receive the right things in a clear, workable way? Think of this as a 3-part mini-series that turns a big, intimidating topic into 3 smaller wins. Lesson 1 is about who receives your estate and who does not. Lesson 2 is about how distributions are structured, like equal distributions or specific bequests. Lesson 3 is about timing and what-if planning, including what happens when a gift fails and why a residuary clause is absolutely necessary. Each lesson is short, practical, and designed to help you make progress without getting overwhelmed. So, in this lesson, we're starting with the most foundational question of the 3: who receives your estate and who does not? When we talk about who gets what, we need to clear up some terminology first. In everyday talk, we use the words heir and beneficiary as if they are the same, but they are very different in the legal world. A beneficiary is someone you choose to receive something. They are explicitly named in your will to receive a portion of your estate, or we may use the term when telling a financial institution, like for your bank accounts or a retirement plan, who should receive your money after you pass away. An heir, on the other hand, is someone the law identifies to receive your property if you don't have a valid will. If you remain silent, the state uses a formula called intestacy to decide who receives your assets. By creating a will, you move from the state's default list of heirs to your own personal list of beneficiaries. Most people think of beneficiaries as family members, and that's common, but it's not the whole picture. A beneficiary can be a person such as family, friends, or loved ones. It can be an organization such as a charity, school, church, or community group. You can decide to name one person or many, or you can decide to include people and organizations in your will. Many people find great purpose in leaving a portion of their legacy to a cause that shaped their lives, or to a person who meant a great deal to them during life. When naming beneficiaries, you generally have 2 options. You can name specific individuals, or you can name a group, sometimes called a class. For example, instead of writing in your will, "I leave my estate to Jack Smith, Jill Smith, and Emma Smith," you can name the group and write, "I leave my estate to my grandchildren." Naming a class can be a very smart move because it acts as an automatic update. If a new grandchild is born after you sign your will, they are automatically included in that class without you having to draft a new document. This is also how we handle afterborn heirs, children who might join your family after the will is finalized. But group wording can also create confusion if family relationships are complicated. Imagine someone named Maya who writes, "To my children." At the time, she has 2 children. Years later, she has a 3rd. The wording naturally includes that child, which is exactly what Maya would want. No change is necessary. Now imagine someone named Andre who writes, "To my children." He has 2 biological children. He also helped raise his stepchild for many years, and everyone considers him a parent. Depending on the law and the details, that one phrase could lead to hurt feelings or disagreements, not because Andre did anything wrong, but because he didn't spell out what he meant. So what is the best way to proceed in your case? The goal is to match the words in your will to your real life. If your family situation is stable, without any expected changes, and you want precision, naming people by name may be appropriate. If you want your plan to automatically include future children or grandchildren, naming a group may make sense. If your family is blended or your relationships are unique, extra clarity can help. That might mean defining what you mean by children, listing names, or doing both. And let's go back to those afterborn heirs or later discovered heirs. That phrase sounds dramatic, but it's usually about ordinary life. A child is born after the will is signed. A child is adopted. Or someone appears who claims to be a child. You don't need to assume the worst to plan for this. You just need a sentence that makes your intention clear. But what if you intentionally want to leave someone out? This is called disinheriting. Life is complicated, and there are many reasons why someone might choose this path. The biggest risk here is silence. If you simply ignore a child in your will, they might be considered a pretermitted heir. The court might assume you just forgot them, and they could still receive a share of your estate. To disinherit someone effectively, you must be explicit. You don't need to be mean or share harsh feelings. In fact, it is recommended you keep it factual and unemotional to avoid a will contest, which means someone attempts to invalidate a portion of your will. A simple statement like, "I have intentionally made no provision for my son George," is often enough to make your intent clear to the court. You should also be aware that there are state limits to who you can exclude. As mentioned in an earlier lesson, and as we'll explore more in a later lesson, in most states, the law protects your spouse through something called a spousal elective share. This means even if you try to leave a spouse nothing, the law may grant them a specific percentage of your estate anyway. There are also protections in some states for minor children to ensure they are supported. The exact rules vary by state. The takeaway today isn't the details. The takeaway is this. If your plan involves excluding a spouse or not providing for minor kids, that's a pause and get guidance moment, because state law may have guardrails. The biggest risk to your legacy may not be the choices you make. It is more likely to be silence on a subject, assumptions, or vague language. If your will doesn't clearly state who should receive your assets, or if you forget to include a residuary clause to catch any leftovers, you're leaving the door open for the state to step in and use its own formula. A residuary clause is the part that says who receives everything that's not specifically handled elsewhere. That includes things you forgot to list, things you acquire later, and gifts that fail for some reason. Without that, some property may slide into the default state rules, and the people you intended to exclude could still end up receiving something under those default rules. Think of your will as the script for your family's future. If you leave a character out of the script or give them a vague role, the actors, which may include the court and your family, will have to guess your intent. By being proactive and clear today, you ensure that the story told after you're gone is exactly the one you wrote. Okay, let's turn this into action. Just by watching this, you've learned how to identify your beneficiaries, how to use class gifts for flexibility, and why being unquestionably clear is the kindest thing you can do for your family. If you're ready for a small step, just take a piece of paper and write down the names of the people and causes you want to include. Don't worry about how much yet. We will cover that later. Just focus on the who. Then, also include an excluded list, if you have one. But include only those who may think they will be inheriting something from you, but that is not your wishes. Again, no explanations. Just the names. Finally, pick whether you prefer naming individuals, naming a class like my children, or a mix, and write one sentence about why. That sentence helps you stay consistent later. And if you want to go deeper, there are optional resources that can help you understand state-level variability at a high level and help you review any existing documents for alignment. You're starting the map of your estate plan. The next lessons, how you structure distributions and how you plan for what if, get so much easier because you're not trying to solve everything at once.